To hear the full episode, become a patron at patreon.com/deathpanelpod.
Welcome to the Death Panel. Patrons, thank you so much for supporting the show. None of the work that we do would be possible without you. To become a supporter of the show and get access to the second weekly bonus episode, as well as the entire back catalog of bonus episodes, become a patron at patreon.com/deathpanelpod. And to help us out some more, share the show with your friends, post about your favorite episodes, pick up copies of Health Communism, A Short History of Transmisogyny, and Abolish Rent at your local bookstore or request them at your local library, and follow us at deathpanel_. I'm Beatrice Bolton, and I'm really excited to be joined today by Mohini Mookim and Veryl Pow, the authors of a fascinating new essay published on the Law and Political Economy Project blog, which is called From Movement Lawyering to Prefigurative Lawyering, Living Out Liberatory Values Now. Now, the piece challenges the idea of law and the state as, quote, a neutral vessel capable of seismic transformations, and instead calls for an orientation toward the abolition of capitalism. It's a deeply thought-provoking framework, one that invites us to think about what it means, as the authors put it, to hospice away the law. So first we have Mohini Mookim. Mohini is a staff attorney at the Sustainable Economies Law Center, and their practice focuses on land justice and wealth redistribution. She is deeply committed to abolition, land back, and anti-capitalist solidarity economies. Mohini leads the Law Center's wealth redistribution work. She works to shift wealth out of extractive financial systems into grassroots movements, and to liberate land and housing from the speculative market by supporting collectives led by Black, Indigenous, and poor people. Mohini, welcome to the Death Panel. I'm so excited to get the chance to talk to you.
Thank you so much for having me. I'm really honored to be here.
And second, we have Veryl Pow. Veryl is also a staff attorney at the Sustainable Economies Law Center, as well as an associate professor of law at Northeastern University. His work, teaching, and scholarship are informed by years of grassroots organizing around Palestine and Third World solidarity, and time that he spent confronting traffic court debt in South Los Angeles. He encourages movement lawyers to support grassroots prefigurative efforts that are attempting to remake social relations to land and people, from extraction and competition to stewardship and mutual aid, rather than litigate or legislate to reform the harms of a broken system. Veryl, welcome to the Death Panel. It's so great to have you here.
It's really nice to be here.
And thank you both so much for writing this essay. I really, really appreciated reading it. And I wanted to just start by laying out a bit of context for what we're here to talk about today. As I mentioned at the top, your piece called From Movement Lawyering to Prefigurative Lawyering lands at a moment when I think a lot of people, especially those actually outside the legal world, experience the law as a kind of dead language of domination, for lack of a better framing. You know, courts, statutes, property regimes, all of it feels engineered to protect capital and hierarchy and not to free anyone. And it feels rather impossible to imagine otherwise at this moment. And yet what struck me about your essay is that the way it opens a very different angle of approach. You're not defending the law or arguing for better policy tweaks. It's not sort of a Pollyanna approach to thinking through the law. You're offering a way to understand law as a terrain of struggle and something that can be repurposed, even if only temporarily, toward building new social relations. And you're naming the limits of, for example, reactive lawyering and the ways that movement lawyering can still fall into state-centric thinking, while also insisting that there's still real political possibility in practicing something different. And you write that with the far right consolidating state power, the traditional horizon of legal reform has basically collapsed. But instead of despair, you treat that collapse as an opening or an opportunity, a chance to think and act beyond the state altogether. And at the core of the essay is this idea of prefiguration, the insistence that liberation can't be deferred or put off to some future rupture, but has to be lived and practiced in the here and now in the ways that we work and organize and relate to one another. And I think that's just such a different way of approaching thinking through the law right now and the contradictions of the law. It shifts the question away from what we can win inside of existing systems toward how we can reshape our relationships to those systems, which I think is so important. And I think that's a conversation that matters to everyone, not just lawyers, because it speaks to the kind of broader challenge of how we live differently from within collapsing institutions without falling prey to reproducing their logic. So maybe to start, could each of you just give listeners a sense of what is this essay arguing? In your own words, what is the core intervention that you're making here? And what felt most urgent to articulate in this moment?
Yeah, I'm happy to jump in and share a little bit about First of all, just the contradiction that's inherent in the phrase prefigurative lawyering. And I think actually your framing, which I really appreciated just now, brought that out, which is that prefiguration, the world that we want to live in, probably doesn't have lawyers. And and so there's like a contradiction inherent to the idea that prefigurative lawyering is even really possible when the legal work that we have to do to support prefigurative projects involve dealing with kind of inane bureaucratic structures that are designed to suppress the kind of agency of poor people movements. For example, Poor Magazine that we work alongside. And yeah, so I think one of the core arguments that I think we wanted to make in this piece, and the reason that we were excited to publish it in a legal blog, was because we just wanted to put this tactic of prefigurative lawyering, to the extent that it's possible, on the table for something that is worth considering, especially given the failures of the limited possibility of federal reform right now. Just to kind of emphasize that, like, this is not something that you'll learn about as an approach to, quote, public interest lawyering. And it's not really well known as an approach, although grassroots movements and the lawyers that have supported them, I'm sure, have been doing this under different names for decades. But it continues to be on the kind of margins of what people think of as even social justice lawyering. And also just to name that, like, and maybe Veryl and I kind of have different, tolerances for different tactics, different tolerance for policy work, for example. I'm working a lot on a corporate housing speculation ban, so a ban on corporations purchasing single-family homes in a local city. And that is not a prefigurative approach. That is like a, more typical law reform approach, although hopefully this is a demand. I mean, this is kind of a demand that has not really been fleshed out by lawyers and policymakers. So that's why I'm excited to work on it, because it is a new sort of intervention in the housing policy world, just banning corporations altogether. So I can't say that prefigurative politics and that the tactics that we're describing in this piece of world building beyond the state, beyond capitalist relations, is the only thing I think is worth doing, because that's not the only thing I'm doing.
I'll jump in to add maybe a few thoughts. One, just to respond to what you ended on, this policy that you're trying to get through a local city council right now isn't prefigurative per se, but should it be adopted and passed by the city council, lays the groundwork for prefigurative experiments to proliferate, like homefulness, which we discussed in our piece. So I think there is, a less of an absolutist position of like, what is the line between quote unquote traditional movement lawyering and prefigurative movement lawyering, or what is a level that sort of state engagement that allows us to sort of claim prefiguration. I mean, that's really not the point if it is really about remaking social relations in the here and now, because the here and now is a capitalist system, a colonialist system based on the law, the rule of law, whatever that means these days. And I think for me, the point is how to strategically use some of our training to soften the rigid barriers that prevent world-making experiments like homefulness to exist. So by banning corporations in your example, I think it allows for alternative entity structures that are more relational and collective by nature to step in and steward and decommodify housing. So I think that's one point. And just to maybe take a step back to sort of just what is it we are arguing? I think it's easy to step into nihilism right now and despair, and we feel it in our bodies. I feel it in law students that I teach on a daily basis. I teach property law, which is a foundational first-year law course where students learn about land as property, as private, a commodity or asset that is privately owned. And that is a source of despair. And I think what is fascinating in sort of thinking through prefigurative politics in relation to lawyering is how can we reconfigure the tools of the system, such as property law, and make it more rehumanize or recommon this concept of private property ownership in showing creative use of legal mechanisms to decommodify land and housing. And these are ways to expand what is possible and, again, reconfigure our own relationships to land and with each other. And I think that's also very distinct from how traditional movement lawyering approaches the system very reactively and defensively. When I was a law student myself, my understanding of movement lawyering was grounded in sort of defense of civil rights, defense of arrestees at actions, and very litigation focused. And right now, students and movement lawyers who are thinking in these classical, traditional ways of reaction are stuck, because how can we possibly win on any reasonable scale these things where the system, the judicial system, is just stacked against us, right? So, instead thinking of movement lawyering as just supporting the creative experimentations that we see through mutual aid projects, through world-making projects in the here and now, and then applying laws affirmatively or applying legal strategies affirmatively outside the context of litigation to both, I guess, expand the experimentation going on and protect them from administrative and bureaucratic hurdles.
To hear the full episode, become a patron at patreon.com/deathpanelpod. You'll get access to this and the rest of our catalog of patron-only episodes, and be the first to get a new patron episode every Monday when it drops. With love, the Death Panel.